This week, we're going to be talking about administrative agencies and discrimination. We're going to be talking about racial discrimination, discrimination based on disability, gender discrimination, and other kinds of discrimination. And as we go forward, it's important to keep in mind that there are actually two different kinds of discrimination that we're going to talk about, and we need to keep these two different kinds of discrimination very distinct in our mind, because the legal foundation for combating these two kinds of discrimination is entirely different. So one kind of discrimination that we're going to be talking about is public discrimination. And when we talk about public discrimination, I'm referring to discrimination by the government, whether it's a state, local, or federal government. Public discrimination, I'm not talking about businesses that are open to the public, I'm simply talking about the government. And public discrimination is governed by the Constitution itself. We're going to talk about the 14th Amendment and the Equal Protection Clause, but those are the important concepts to keep in mind when we're talking about public discrimination. We're also going to be talking about private discrimination. Private discrimination, of course, is discrimination by non-governmental actors, so private businesses, nonprofits, and others who are not part of the government. And private discrimination is governed by an entirely different set of laws. They're governed by statutes. And so we're going to talk about these two things differently because those different foundations have significant implications. And this is a good transition week for us because, as you'll recall, I said that we would be spending the first half of the semester talking about constitutional issues and the second half of the semester talking about statutory issues. Well, when we talk about discrimination, we're going to talk about both because public discrimination is governed by the Constitution, whereas private discrimination is governed by statute. So let's dive in and let's first consider public discrimination, which is covered by the Equal Protection Clause. Now, a lot of people are surprised to know that the Constitution, when it was originally written, did not have a commitment to equality at all. In fact, many people will often quote the phrase, "all men are created equal," but that phrase isn't found in the Constitution, it's found in the Declaration of Independence. And so it wasn't until the addition of the 14th Amendment to the Constitution in 1868 and its Equal Protection Clause that equality was finally enshrined into the Constitution as a constitutional value that government was dedicated to pursuing. The Equal Protection Clause is part of the 14th Amendment. The 14th Amendment is long and it does a lot of things, but the Equal Protection Clause is this particular portion, and we want to take a close look at the text. It says, "No state shall deny to any person within its jurisdiction the equal protection of the laws." So there are two big questions that have come up as a result of this. Of course, one is, what is equal protection? That phrase is very ambiguous, and there have been lots and lots of court cases devoted to answering that question. And the other issue is, who is any person? Any person is very broad. It obviously applies to everybody, and yet laws discriminate between people all the time. For example, drinking ages discriminate between those individuals that are under 21 and those that are over 21. So the question is, which groups will actually receive the protection of the Equal Protection Clause? How will the court interpret that phrase, any person? So the Equal Protection Clause has probably led to more litigation before the Supreme Court than any other part of the Constitution. So it's a very thick, very rich area of law. Of course, we'll simply be scratching the surface this week as we go forward. But again, what groups does it protect? And what is equal protection? If a group gets it, what is that? Those are the two things we'll be focusing on. So the Equal Protection Clause was added to the Constitution in 1868, but the Supreme Court did its best to make sure that the clause was a dead letter and that it really had no practical effect. And of course, One of the most famous, one would say infamous cases that the Supreme Court ever decided was the case of Plessy v. Ferguson in 1896. And Plessy v. Ferguson involved this gentleman, Homer Plessy. And Homer Plessy, don't know if you can tell his race simply by looking at him, and that was part of the point. In this particular case, Plessy v. Ferguson, Louisiana had a state law that required the separation of races on the train, or on trains, I should say. Now this is important because this was in a Louisiana state law. This was not merely a train company policy. If it was a train company policy, that would be private discrimination, and we wouldn't be talking about it here. But this was a Louisiana state law that required the separation of races on trains. Even if a train company wanted to integrate its passengers, it would have been forbidden by Louisiana state law. So this is public discrimination that is, or should be, prohibited by the 14th Amendment. Homer Plessy got himself arrested intentionally in order to challenge this law before the Supreme Court. He was an African American. He alerted the authorities that he would be violating this law by attempting to sit in the whites-only train. He was arrested. The case went to the Supreme Court, and they upheld the law by an 8-to-1 vote, despite the Equal Protection Clause. And this is the famous case in which the court established the separate but equal doctrine, in which they said it's okay constitutionally to separate the races as long as the facilities you provide them are equal. Of course, in practice, the separation was strictly enforced, the equality rarely was, and of course, this inaugurated the entire era of Jim Crow laws that required whites and non-whites to drink from different drinking fountains, use different bathrooms, sit in different sections of theaters, and so on. So Plessy v. Ferguson essentially reduced the Equal Protection Clause to nothing just a couple of decades after it was passed. Now this is not a class to go into all of the cases. There was a complex path between Plessy and Brown v. Board of Education. But for our purposes, we're going to leap forward about 60 years in time to when the Supreme Court finally effectively overturned Plessy v. Ferguson. In this case, it was a 9-0 decision. They overturned Plessy v. Ferguson. Brown v. Board of Education, of course, had to do with integration of the public school system, not trains, but the court effectively banned all governmental classifications based on race. Essentially said that virtually all governmental classifications based on race are unconstitutional. And so what this means, and this is important to keep in mind, that racial discrimination by the government is unconstitutional, and there's no additional legislation needed for that. You don't need to pass a law or anything. It's banned by the Constitution directly. So racial discrimination in virtually all instances is unconstitutional. But of course, this raises an interesting ongoing question, though. What about affirmative action? Affirmative action is a program that uses race to make decisions, but it does so in a way that is not typical of our historical practice, and that is it's designed to help racial minorities rather than to hurt racial minorities. And so one question that the courts have had to deal with, that California has dealt with, and administrative agencies, of course, often have to deal with, is the question of affirmative action and its constitutionality. We will discuss that later on in this lecture or in a later lecture. So let's talk about how the Supreme Court has gone about interpreting the Equal Protection Clause. And as we've already mentioned, the fact of the matter is most laws discriminate. Most laws treat people differently. Poor people may get governmental benefits that rich people are not entitled to, and so on and so forth. And so the question then becomes, what kinds of discrimination are permissible under the Equal Protection Clause, and what kinds of discrimination are not permissible under the Equal Protection Clause? And in order to answer that question, of course, the Supreme Court has created a couple of important tests that you should be familiar with. And the fact of the matter is, most discriminatory laws must merely meet the rational basis test. And we're going to talk about the rational basis test, but you've already encountered something very similar to it when we talked about lawsuits that try to challenge agency actions on grounds of substantive justice. You'll recall that when agencies are challenged on matters of substantive justice, in other words, lawsuits that say they simply reached the wrong decision, the courts usually throw those lawsuits out and only uphold them if the government's action was completely arbitrary. That's very similar, as you'll see, to the rational basis test. But laws that discriminate on the basis of race have to meet typically a much higher test and a much more difficult test called the strict scrutiny test. So the strict scrutiny test is a little more difficult to understand than the rational basis test, but let's talk about each of them in turn. So first of all, let's talk about the rational basis test. The rational basis test is the easiest test known to the law. Whenever somebody challenges a law or governmental action as violating the Equal Protection Clause, the government has to explain why did it pass this law. It has to provide some sort of justification for the law. It has to have a reason, in other words. And what the court will then do is it will examine that reason. It takes a look at the objective of the law, the reason the government has given for passing it. And it will ask, first of all, is that objective lawful? Is it trying to achieve something that's lawful? And the second question is it rationally related to achieving that objective? So if the government is trying to, if it's trying to do something illegal, then of course the law is invalid. But if it's trying to do something that's legal, the law merely needs to be rationally related to achieving that objective. It doesn't need to be the best way of achieving the objective. It doesn't even need to be a good way of achieving that particular objective, as long as it's rational. And of course, government very rarely does things that are completely irrational, and as a result, the government is usually able to satisfy this particular test. Again, the rational basis test is the simplest, easiest test for the government to pass under the law. And when the government, when the court uses the rational basis test, it usually means that the law is constitutional. Now, having said that, I want to point out that sometimes there have been examples of laws that don't even pass the rational basis test. So even under the rational basis test, not all laws can pass. And one of the most famous examples, of course, was the case of Loving v. Virginia, which was decided by the Supreme Court in 1969. Loving v. Virginia involved a law from the state of Virginia. Virginia was one of 17 states that made it illegal for people of different races to marry. So if you were a white, you could not marry a non-white person, and vice versa. And the Supreme Court overturned this case, or overturned this law in 1969, and it did not even use the strict scrutiny test, which it could have used, but it simply used the rational basis test, and it said laws that prohibit individuals from marrying others of the same race are based entirely on racial animus, racial hatred, and that is irrational, and therefore there is no rational basis for these laws, and it violates the 14th Amendment. So racial animus, racial hatred, is something that the court has classified as irrational, and if a law or governmental action is based on it, then that law or governmental action can be tossed. Your book contains another example of a case in which the Supreme Court used the rational basis test to throw a lawsuit out, to void a law, I should say. This was Colorado's Amendment 2, which prohibited prohibited local governments in the state of Colorado from adopting any ordinances that would protect gays against discrimination. I leave you to read this case and to take a look at the court's rationale in this particular case. But I want to make clear that these two cases are an anomaly, because in both of these cases, the Supreme Court used the rational basis test and struck down a governmental law or governmental action. That is unusual, because usually when they use the rational basis test, that means the law or action will be upheld, because it's usually an easy test to meet. Usually the government is not basing its action solely on animus, but sometimes it does. So there's another test known to the law, and that is the strict scrutiny test. And as the name implies, this is a much harder test for the government to pass than the rational basis test. Under the strict scrutiny test, the government cannot be pursuing merely a lawful interest. If you recall, under the rational basis test, the government only had to be pursuing a lawful interest. Well, under the strict scrutiny test, of course, the government has to be pursuing a lawful interest, but that interest also has to be compelling. In other words, it has to be a particularly important governmental interest. The government may have lots of interests, but some are more important than others, and this has to pass some sort of threshold. Now, what is a compelling governmental interest? We can probably see more by example than an actual definition, because the beauty's in the eye of the beholder. But the government has to make a case that this law was passed for a really good reason. But not only that, the law has to be narrowly tailored in order to achieve that interest. In other words, the government may be doing something it has a right to do, and it may be very important, but we need to make sure that the legislation is not broader than it needs to be, that it doesn't implicate or undermine people's rights more than it needs to. And another way to phrase that is that the government has to use the least restrictive means in order to achieve that interest. So in other words, the government has to be doing something really important, and whatever law it is passing or action it is taking has to be narrowly focused on the interest that it is designed to achieve. If it's too broad, it may be struck down, even if the interest is compelling. So, as in most of these tests, you've got a series of questions. In this case, we've got 2 questions, and failure to meet either one of these criteria means that the law is void. As indicated earlier, it's a very difficult test for the government to meet, and when the when the court uses the strict scrutiny test, it is essentially indicating that it plans to strike down the law or governmental action. So again, to summarize the strict scrutiny test, you've got 2 questions. The first question is, does the government have a compelling interest in the action? And if the government doesn't have a compelling interest in the action or the law, then the action or law is unconstitutional and the case is over. However, if it does have a compelling interest, then the court will go on to ask the next question, and that is whether the action or the law is narrowly tailored to achieve that interest. And if it is not narrowly tailored to achieve that interest, again, the law or action is unconstitutional and the case is over. So there's a case excerpt in your book, once again, that I'll leave you to read, FSK Drug Corporation v. Perales, but it involves the use of these standards of review, and this particular case doesn't have anything to do with racial discrimination, which explains why the court uses the level of review that it does. So this one's a pretty simple case to understand, and I encourage you to read it. Now let's take a look at how the strict scrutiny test is applied in an actual case. We'll take a quick look at the case of Johnson v. California, decided by the Supreme Court in 2005. And this case came from the Department of Corrections and Rehabilitation right here in California. And the policy that was challenged in this case was a policy that segregated inmates along racial lines for the first 60 days of their stay in prison. So white prisoners, African American prisoners, Latino prisoners, Asian prisoners would be segregated and housed separately for the first 60 days. And of course, this action is clearly based on race. Nobody disputed that. And so strict scrutiny was the test that was to be employed. And so the first question, of course, that the court asked was whether the government had a compelling interest. So the Department of Corrections had to explain why they adopted this policy. And the policy, they said, the rationale, they said, was that it helped reduce gang violence. And so the court had to evaluate whether that represented a compelling governmental interest. And that's pretty easy. The court has in the past found that many things, most things related to the administration of prisons fall under the compelling interest. And so reducing gang violence, absolutely a compelling interest. So the government was able to meet the first part of the test. But the problem, according to the court, was that this was not narrowly tailored, that it was too blunt, too broad. It affected every inmate, that there were, according to the federal government and to other states, other ways that one could achieve a reduction in gang violence. And in fact, so the court said, by perpetuating the notion that race matters most, racial segregation of inmates may exacerbate the very patterns of violence that it is said to counteract. So, good try, California. You certainly want to reduce your gang violence, but using this broad racial categorization is not the way to do it. So this failed the strict scrutiny test. There are lots of other examples out there, but this is a good one, I think. So we'll wrap this lecture up, but the next lecture we'll continue to talk about public discrimination, but so far we've only been talking about racial discrimination and public discrimination. But the guarantees of the 14th Amendment's Equal Protection Clause go beyond protecting individuals against racial discrimination, and in the next lecture we'll talk about how far do its protections extend.